Okay, everybody, you should be done with your midterm at this point in time in the course, meaning we're about halfway done. We've allowed chapter 6, 7, 8, 9 with a few extra labs that we could hopefully get time to do. If not, you'll have other chances to do that in your other courses, but it's always good to do it more than once. So for chapter 6, we're going to be examining case study from beginning to trial, where we'll have our lecture notes, the assignment that we'll be doing this week, where we examine the tools that courts use, presentation tools that courts use. We'll be looking at trial directory, sanction, and visionary. So PowerPoint is pretty common, but not utilized very well in trials. So don't bother with PowerPoint. Our forum this week is to go over chapter 6 in your book and find information regarding pre-litigation e-discovery investigation practices, where we deal out a timeline for both criminal and civil cases, the purpose of the investigation stage, and make sure you list out what incidents might occur. There are a lot of them, so you get a lot of free time or freeway with this. Leeway, I should say. So these data sets can, for case evidence, can include a lot of stuff. Just list some or what you found to be really interesting. Make sure you make your post by Thursday this week to allow time for your peers to review and make the appropriate comments. Remember, your reply has to be done by Sunday, the end of the week. Make sure your length on your reply is more than 3 sentences or more than 1 paragraph, not just 1 sentence or a couple of words. Good post. Wow, that's interesting. That's not enough to be considered a valid reply. You'll go through chapter 6 review questions, which will unlock chapter 6 quiz. And with that said, let's get started on our chapter 6 notes. So we'll learn to describe the pre-litigation e-discovery investigation practices, the common discovery documents used when starting a formal lawsuit, the discovery project management tasks, including sampling and metrics, fact-finding and pretrial motions, common technical and non-technical considerations to take in trial presentations. Not everyone is an expert, so you'll need to make sure your terminology works for the jury or the judge, depending on civil or criminal or pretrial or trial. Establishing the basis of the lawsuit involves early fact-finding that lays the foundation for the initial claim. It's not unusual for a case's basis to expand as an investigation, and discovery often yield more information later on. Before a complaint or indictment is filed, a preliminary investigation should reveal some fact about the case for this litigation. In civil cases, the client is interviewed and any preliminary evidence is evaluated. In criminal cases, covert actions such as wiretaps, body wires, or other recordings may occur. During the investigation stage, the goal is to capture as much discovery information as possible before litigation, before a legal hold or notifying the opposition of the potential litigation. Discovery might include websites, video, social networks, information from government media or resources, geospatial or mapping data, webcam, cell phone, video, voicemail, and on the list goes. Some advanced techniques include analytic features that are marketed for law enforcement, but are also used in civil litigation. An example here is the Analyst Notebook and Social Network Analyzer. There's also a few Facebook analyzers as well that are really cool. These tools represent a visual representation of large data sets like phone and bank records, IP addresses, traffic, social networking diagrams, analysis, geospatials, tree maps. The formal litigation can start if enough information has been collected to pursue the case further. Starting litigation involves a wide variety of documents to put the case on record with the court, notification of potential parties and their duty to preserve that evidence, and undertaking additional discovery in different forms. A legal hold is the order to preserve data in anticipation of litigation, audit, or government investigation, or another matter. It keeps people, clients, lawyers from destroying or processing records, and it makes the also known as litigation hold, preservation letter, suspension order, and others. Typically used a lot in civil cases. Criminal prosecution more commonly involves search warrants, search and seizure laws, during the investigation stage. A legal hold, destruction of evidence by the prosecution, is prohibited by the Brady Doctrine, Jinx Act, and the Gigolo, even without notice from the defense. Destruction of evidence is a crime. Deliberate destruction of evidence can result in criminal prosecution under the Sarbanes-Oxley Act, as well as legal sanctions, possibly even if it's a lawyer, like we watched in one of our DEF CON videos, the disbarment or loss of legal license. So that's what they mean by sanctions. The main reason for requesting party to issue a preservation is to lay the foundation of sanctions in a case of spoliation. A legal hold in form of a preservation letter should include the locations of the data, the types of data, lists of key custodians, list of things not to do, such as moving, deleting, overriding, upgrading, defragging, and contact person for questions. The request for admission usually follows a preservation letter. It's written statement that asks the party to admit or deny certain case facts, to ascertain what items aren't in controversy, to limit further investigation and discovery. Some courts might deem a failure to respond as admission of the facts as an admission. Some courts might deem a failure to respond as an admission of the facts addressed in the RFA. So if your prosecution submits an RFA to the defense, the defense doesn't respond, the defense just accepted everything on that list. It can be useful to have IT or computer forensics person to address these technical issues in drafting an RFA to the opposition. After the RFA has been issued, detailed interrogatories usually follow. They're combined with the RFP and possibly supplemental RFAs. In criminal cases, FRCRP 16 governs discovery. The criminal counterpart to an interrogatory is called a bill of particulars. Parties must meet as soon as practical or before certain court deadlines. The scope of the meeting is intended to encourage the parties to agree on litigation issues early in the case, including the possibility for settlement, discovery, and other resolutions. The meet and confer should address topics such as the types and forms of ESI to be produced. Meet and confer can help cost sharing, can be used for hiring one vendor to process the native files to TIFF for all parties. The meet and confer is also the time in which access to computers or servers in question and procedures are followed. Search procedures should be established, like keywords, custodians, date ranges, locations, and any other matters to help identify discovery as specifically as possible. This is intended to reveal potential disputes on schedules and discovery. The court expects both parties to participate in good faith. Failure to do so can also result in court sanctions. Criminal cases aren't directly affected by FRCP 26F. Courts do encourage early case resolution or discovery planning in criminal and civil and criminal cases. The request for production is the main form of requesting discovery in civil cases. In criminal cases, the motion for discovery is the counterpart to an RFP. These identify information being sought and can include documents, data, formulas, recipes, videos, bank records, access to land, data, buildings, expert witness, products, anything in the party's possession or control that's related to litigation. The request for production in civil cases, volumes of non-relevant data might be produced. Part of the strategy to inundate the opposition and hide relevant data. Today, these document dumps are likely to be challenged in court. Proportionality under FRCP 26b2, the process of limiting the burden of discovery by weighing it against its likely benefits, can also be applied to criminal cases. In criminal cases, the prosecution often produces all material, even if it isn't relevant. They do this to avoid violating the Brady Doctrine and requires disclosing all documents that might show innocence or otherwise affect the trial's outcome. In both civil and criminal cases, subpoenas are used to produce additional RFP or discovery motions. The subpoena ducis tectum is a command for a person to appear with certain evidence or to permit inspection of property. A subpoena, in short. When seeking discovery or transmitted over the Internet and Stored Communications Act can apply, the SCA. SCA lists 5 ways these records can be obtained. Subpoena with previous notice to the subscriber or customer, court order with a previous notice to subscriber or customer, and then finally, search warrant. The main difference between a subpoena and search warrant, a subpoena commands the person produce it. A search warrant permits law enforcement to go in and seize that if there's probable cause that a crime has been committed. Both can be challenged in court, and the motion to quash is a legal procedure used to reject, invalidate, or suppress evidence. Before receiving discovery under an RFP, the preliminary project management plan should be created. The plan should identify the team, technology and tools, quality control points and methods, potential vendor support, project budget and timeline, case goals and objectives. The plan is updated as the case progresses. Having well-documented e-discovery review process is helpful in defending against possible negative allegations. When discovery is received, a document or chain of custody log should be created, which includes detailed items such as date, type, media label, data, etc. The sampling and metrics. Sampling is performed to test a variety of files, application compatibility, viewing, and processing. Also used to review files for additional keywords, review information to broaden discovery scope. Metrics is the activity measurement to gauge how much time is needed to process and review certain quantities of e-discovery. And you may ask yourself, well, this is all fine and good, but I'm not interested in this. At least sampling and metrics are part of your everyday IT life. So even if you're not interested in e-discovery, it's important to note that this phrasing and keywords will show up again in your everyday life. I promise you it will. You'll be set to a sample, which is a variety of things that happen, and they'll say that this goes on all the time. It's a standard. The metric will hold you to that sample, the sample that says, and this type of call, which would be an email problem, you should take no longer than 10 minutes to resolve. The metric measures your success rate in that, or how much time is needed to review. These metrics and samples are important components for project management, which would tell your boss, the project manager, how much people he needs on the floor because he gets 10 email calls a day or he gets 500 email calls a day. Before copying narrative discovery files to a document, determine whether any have any viruses that can alter metadata or standalone computer that run the tools, extract and preserve the metadata, and identify encrypted virus or other problem files known as exceptions. Tools to use like LAW, Discovery Cracker, IP Pro, eScan IT, ImageMaker's Discovery Assistant. Sampling is done in order to establish metrics, identify known file types or unknown file types that might need special attention or software or viewers, Verify the accuracy of the search methods. Identify keywords to expand search parameters. These metrics are gathered to establish or estimate the time and cost to manage, process, and review. Verify the accuracy of searching and reviewing these procedures. After doing the metrics and sampling, you should select discovery tools, vendors, and staff members. Just forensics tools such as Forensics Toolkit Imager, FTK Imager, are usually needed to preserve and copy digital discovery, like metadata, operating system files, and possibly storage media. Discovery Attender can search and identify files containing keywords and generate reports without altering the metadata. Web-based reviewing platforms can also be used for viewing and processing unusual file types. Another factor in selecting tools and determining key factor is going to be used for trial arbitration mediation. Key discovery is also known as hot docs. Note, when file formats will be imported in trial presentations such as trial director, sanction, and visionary. Selecting e-discovery team members depends on what tools are being used, the nature of discovery, complexity, expected size, and deadlines. A review team of paralegals, junior attorneys, IT staff with adequate technical training or certification usually manages cases better. Vendors such as digital forensics and consultants, web-based review platform providers, litigation process houses, document review services, trial consultants may be needed. During the EDRM stage between collection and presentation, discovery is organized in notebooks or folders to keep track of chronology, issues, witnesses, experts, and trial outlines. The review platforms offer features such as tags and folders, sorting, and categories helps aid in organization. Software or offering more detailed or specific case organization, the LexisNexis Case Map and Time Map. Preliminary case issues and strategies are usually formed during the initial investigation, but can be revised during the meet and confer when discovery is received and reviewed after depositions and other fact-finding probes. When case issues move past 30 to 40, often means review staff can't organize large volumes correctly. Too many issues can lead to confusion and the important issues get lost. Case issues should be well-focused and grouped from the start so that review staff can work with consistency. A team leader should be selected to conduct quality control and frequently detect where problems might happen. The process of identifying naming database fields takes the following factors into consideration: the nature, field types or file types, number and location of team members, co-counsel, and other parties who need access, security, and other legal issues. Databases have key fields, unique numbers or identifiers used for image or data files. Security and access rights needs to be set up for reviewers, remote staff, or other consultants or other database users. Team leaders or project managers should have broad access to monitor the review team's activity, keep track of metrics, and use reporting features. Lead attorney and review staff should have more limited security and access rights. They are mainly searching and tagging documents. Lead attorney may need to run reports. Document coding involves entering data in database field manually or automatically. Metadata often needs additional processing too. The normalization or coding or reformatting information to consistent syntax that allows accurate field searching or sorting. Organizing discovery also involves unitization, which is assembling separate items such as pages or attachment into complete documents. During the meet and confer, parties should specify how to assemble the documents with attachments or embedded data, like emails, Word documents, Excel sheets, spreadsheets. The goal of coding, normalization, and unitization efforts might depend on whether documents' content is important or whether the documents were handled crucially to the case storyline. Creating the coding manual and project manual can help prevent problems and ensure consistency. For in-house discovery processing, quality assurance checks should be implemented at every phase. Discovery inventories and chain of custody are critical as well. OCR quality, resolution, and other factors should be checked often. Monitoring logs, database, imports and exports ensures no discovery has been omitted or inadvertently left out. Metrics are typically gathered stages of case processing, often at the same time quality checks are done. Metrics are used to evaluate time and budget concerns. Without metrics, knowing whether certain stages of e-discovery could be completed before a case is ready to go to trial on time would be difficult. Most cases would go over budget. Fact-finding is the process of reviewing discovery to gather evidence that's relevant to case issues. Usually begins during pre-litigation investigation, but continues throughout the life cycle. They can involve computer forensics examinations and used to review, organize email documents, audio, video, or other case materials. They should include material that can support both sides of the argument. Today, different search concepts and methods are used depending on factors such as the nature of the case, skills, and legal staff. Some methods include fuzzy stemming, wildcard searches. The second method should be used to identify search results that are applicable or acceptable. Early case organizations and fact findings are necessary to pretrial motions and prepare effective trial presentations. For pretrial motions that are used to eliminate legal contentions or limit the evidence before trial, they often result in facts discovered from evidence during the review. They are usually court rules with specific deadlines for filing motions and responses. Maintaining regular quality checks as discovery is reviewed and organized helps you prepare and respond to these motions promptly and accurately. A motion to compel forces the opposition to produce evidence previously requested but not delivered. Some law firms do not process e-discovery until the last minute, hoping the case will be settled to avoid that expense. The tactic usually results in costly mistakes, poor outcome, not to mention possible spoliation, court sanctions, or malpractice. Properly processed e-discovery make quick retrieval of key information for pretrial notions or trial presentations possible. Trial tools, in addition to PowerPoint, trial director, sanctioned visionary, that's part of your assignment this week, have been developed to help work those files in e-discovery review platforms like trial hardware, monitor screens, projectors, audio sound system, wiring, printers, etc. In the past, they were numbered, and they were usually assigned a number based on the numbering series agreed to during the meet and confer. Typically, plaintiff exhibits are numbered first, defendant exhibits are numbered next. When both use the same exhibit, both sides should use the same number so the jury is not confused. Both trial presentation and review platforms should have synchronized exhibit numbers. During the quality control, the same trial exhibits should be in review platform and the trial presentation tool. Be careful that no exhibits are lost when migrating evidence between tools. Also verify that documents in both are compared with presentation outlines prepared by the lead attorney. After all exhibit numbers have been assigned and entered, both review platform and trial presentation tools. Trial notebooks are usually created in paper format that contains exhibits in numerical order. They may have a separate tab with exhibits organized in chronological order. Trial exhibits are exchanged with opposing counsels and filled with court, ensuring that accuracy is crucial. Many courts have updated facilities to accommodate modern courtroom technology. Some do not. It's important to visit the court well before trial to examine the facilities for technical and presentation concerns. Speak with the court's clerk or bailiff about acceptable types of presentations. Some judges object to placing screens in certain parts of the courtroom. Most court proceedings are open to the public and media. Anticipate how this factor might affect the operations. Determine whether equipment or other material need to be stored in the courtroom during recess or other times. Some courtrooms have storage accommodations. Advanced planning is crucial. Things to take in consideration when presenting trial stuff to juries. The software video recorded depositions can be played and synchronized to transcript. That helps for the vision and hearing impaired. Improves the jury's understanding and recalls information and important facts during deliberations. When presenting in digital format, be prepared to give evidence in a portable format if jurors ask to review the evidence again. Materials may need to be converted to a format that's easier for the jurors to view with tools they are familiar with. The use of special technology during trial generally requires the judge's approval in advance. Always communicate simply and clearly what equipment you plan to use. It's a good idea to demonstrate, to have demonstratives available if you need to help the judge understand the technology you're using. Demonstratives are any type of evidence used to explain something, such as flip charts, PowerPoint, slides, physical models, videos. Professionalism and efficiency to the judge go a long way to help toward a successful outcome. So in summation, early case evaluations include pre-litigation, investigation, interviews, and preliminary discussion. Formal litigation begins with filing a complaint in civil cases or an indictment in criminal cases. A meet and confer is a time in which all parties agree on all technical and non-technical discover requirements. The project manager involves sampling and management, I should say, not manager. The basis in e-discovery organization lies in case issues and strategies, which often change and broaden as discovery is reviewed. Fact-finding is the process of identifying evidence to support or refute case allegations. Pretrial motions are used to eliminate legal contentions, dispositive, or limit evidence before trial. Judges have complete control over their courts and often have restrictions on placement or use certain equipment that may or may not deny internet access. So that is our lecture. We're done with this week. Don't forget, you've got your discussion this week, your project, and the quiz and review.